Hello and thank you to everyone who has joined us for today's webinar. As you know, we are hosting a series of webinars focused on FDI development from a European, Asia-Pacific and Middle East perspective, as well as a deal-specific FDI case study involving the USA, New Zealand and Australia. Before we start, few practical details. First, the session will be recorded and the recording will be available soon. And second, you can see at the bottom of your screen two boxes, one for the chat and one for the Q&A. So if you have any question, do not hesitate to raise it and we'll try to answer it at the end of the webinar if we have enough time. We kick off the series today with part one of the European FDI focus webinar, where we will provide an overview of the European Commission's FDI framework regulation, as well as other tools available to the Commission to protect EU and national strategic assets, with views from Austria, France, the Netherlands, and Sweden. Our panel today comprises Tobias Brooklund from Zetterwells for Sweden, Guillaume Briand from Stephenson Harwood for France, Joost Ujic from AKD representing the Netherlands, and last but not least, Bernard Müller and Heinrich Kühnert, both lawyers at Dorda for Austria. My first question goes to Guillaume. Before we take a look at the Commission FDI framework, why have we seen such a significant growth in FDI screening rules worldwide, including in Europe, with a marked increase in importance and frequency of FDI review of deals?
This is correct. We have indeed seen over the last few years a significant increase in FDI regimes worldwide. At the heart of many of the reforms on introduction of new regimes are a number of geopolitical factors, including protectionism and the importance of safeguarding key national strategic assets and technologies, as well as supply chains against disruption and takeovers by large foreign multinational corporations, as well as state-owned enterprise. COVID-19 has especially acted as a catalyst in this respect, looking to protect from takeover businesses that have become vulnerable as a result of the pandemic in sectors affecting health, medicines, including vaccines, medical equipment, such as personal protective equipment, security, and public order. As a result, there has been a general trend to introduce new rules or reinforce existing rules, as in the USA, Canada, Australia, Germany, France, Spain, Italy, and in the UK. Albeit, there are some exceptions, notably China, Chile, that have relaxed the FDI rules to encourage foreign investments.
Thank you, Guillaume. My second question goes to Austria and Bernard in particular. Turning to the EU, it is clear that the power to screen FDI remains firmly in the hands of national authorities. But nevertheless, the Commission has recently introduced its FDI framework regime and mechanism. Why is that?
Thank you very much for this question. It is my impression that in Europe, the FDI regulatory landscape was very fragmented. There have been some member states, in particular France and Spain, which had very strict and efficient FDI control systems in place to monitor and scrutinize FDI, whereas other countries being less active, such as, for instance, Austria, and what we will hear later on, also Sweden and the Netherlands are just in the process of introducing an FDI screening mechanism. Therefore, as a result, member state FDI systems have varied widely in their scope, in particular with respect to investment thresholds, review timetables, whether the review is voluntary or mandatory, and of course, which is even more important, with respect to the level of enforcement. And the various member states have not really coordinated their approaches, even where a given investment might affect several of them. The FDI investment regulation, the EU FDI investment regulation, therefore tries to address the patchwork by specifying a number of characteristics of the new screening mechanism must meet. The framework was spurred on by the COVID-19 crisis and the reasons mentioned just now also, that affect the growing increase in number of FDI regimes worldwide.
Thank you, Bernard. Turning back to Guillaume, can you provide a brief overview of the EU Commission's FDI regime for screening FDI? How does it operate and what's its purpose?
Yes, of course. The framework came into full force on 11 October 2020, but it was initially passed in March 2019, affording member states an 18-month period in which to prepare for its full implementation. More specifically, the framework establishes a mandatory cooperation mechanism between the Commission and individual member states, regardless of whether such member states already have a screening mechanism. Such member states are now required to inform the Commission, as well as other member states, of any foreign direct investment transaction falling within the range of screening within their jurisdiction. Upon receipt of this notification, the other member states then have a period of 15 calendar days to inform the Commission of their intention to provide comments on any such transaction and to ensure such comments are ultimately submitted within 35 calendar days of the original notification. This is in order to enable the Commission to incorporate these comments into its review. Then the Commission itself may issue an official, although non-binding opinion to the other member states who made the referral, advising as to whether, in the Commission's view, the transaction poses any threat to the security or public order of the European Union. Silently, the FDI framework does not afford to the Commission the authority to block any FDI transaction. This decision still rests with the relevant national authority of the member state in question. Another important point to note is that member states can provide comments on transactions that are being planned or contemplated in other member states, even if these transactions are not being reviewed from an FDI perspective or otherwise in those other member states. In such cases, the member states receiving such comments are obligated to pass them on to the Commission. This provision is intended as a safeguard in the event that a particular member state has no system of FDI screening in place, and therefore no basis on which to notify the Commission that it is reviewing a transaction on such grounds. In other words, potentially union-affecting FDI transactions will not fall through the cracks simply because a member state doesn't have an FDI screening regime. For example, according to a leak, in March 2021, the Italian Council of Ministers blocked the sale of 70% of a company based in Milan to a Chinese company. A leak revealed that Sweden and the Netherlands had commented on the case. Going back to the framework, it also provides for some key requirements for national screening mechanism: transparency of rules and procedures, non-discrimination among foreign investors, confidentiality of information exchange, as well as the possibility of recourse against screening decisions. The EU regulation includes an indicative list of factors that member states and the Commission may take into account when assessing whether a foreign direct investment is likely to affect security or public order. It's important to note that following Brexit, given that the United Kingdom ceased to be a member state as from February 2020, the FDI framework does not apply to the UK.
Thank you, Guillaume, very clear. So Bernard, it is right that the framework itself does not require member states to put in place FDI screening rules?
Yes, you're perfectly right. But however, on March 25, 2020, the EU Commission published a set of guidelines on FDI in response to the COVID-19 crisis, pursuant to which those member states that do not currently have any FDI screening regimes in place shall take all necessary steps to establish one, and where no review mechanisms are in place, to use other measures such as restrictions on capital movements or golden shares.
Thank you, Bernard. Guillaume, how many countries now have an FDI regime in Europe as a result? Do they all have screening mechanisms in place?
Well, we've seen a dramatic increase in the number of FDI control regimes, as well as the reinforcement of existing regimes since the framework. As of July 2021, 18 out of the 27 EU member states have some sort of FDI screening legislation in place. Among those, some member states always had some sort of FDI regimes in place, some over a decade old, but those regimes were only used rarely until recently. This is the case of Spain, France, Italy. There have been in other states a certain number of newly introduced FDI regimes, such as in Czech Republic, Denmark, Slovakia, Finland, Slovenia, and Poland. In other jurisdictions, such as Germany and the UK, although it's now outside of the European Union, we've seen significant amendments to the FDI screening regimes. And of course, other countries are adopting new rules or are in the progress of adopting such rules, such as Ireland, Belgium, the Netherlands, and Sweden. Currently, there are only 3 member states that have not indicated their plans on the FDI front, namely Bulgaria, Croatia, and Cyprus.
So interestingly, you have member states that have had an FDI regime in place for years, albeit not very active, and some other member states that have no such FDI regime, but which are looking to introduce new FDI rules. Austria and France have had FDI screenings in regime for some time. How have the FDI regime in Austria and France developed over the years? What has the recent change in policy been due to? I suggest to start with Guillaume.
Well, in France, a major evolution on the regulatory framework was the adoption of a decree in 2014 by the former French Minister for the Economy, Arnaud Montebourg. Pursuant to this decree, the scope of the French prior authorization regime was substantially extended in the context of the contemplated acquisition by General Electric of the energy business of Alstom. Then, later, the adoption of the so-called Pacte law, Loi Pacte, in May 2019 has reinforced the French government's investigative powers, as well as the choice of sanctions in case of non-compliance with the foreign investment regulation. A decree adopted in December 2019 expands the scope of FDI control to new sectors, including food safety, press, and research and development activities relating to energy storage and quantum technology. It also reforms the authorization procedure on the concept of foreign investment and investor. The latest reform results in the exceptional features adopted by the French government in the context of the COVID-19 pandemic, including the extensions of sensitive activities to R&D activities relating to biotechnology before the summer 2020, as well as research and development in renewable energies, as well as the temporary lowering of the applicable threshold to 10% in respect of purchase of voting rights or shares in French companies. The French Treasury announced that it had screened 275 transactions in 2020, a 27% increase compared to 2019, and a 50% increase compared to 2018.
Well, contrary to France, Austria also had an FDI regime in the Foreign Trade Act since 2013, but this regime was largely dead law. At the height of the COVID-19 pandemic during the first lockdown in March 2020, The Austrian Minister of Economics announced that a new strict and effective FDI screening regime should be implemented in Austria to prevent the sellout of Austrian companies as a result of the COVID-19 crisis. With the enactment of the new FDI regime, therefore, the pendulum swung in the opposite direction, and the control of the FDI in Austria is now taken seriously, sometimes, pursuant to my opinion, too seriously.
Very clear. Thank you. So I turn now to Joost and Tobias. So the Netherlands and Sweden are just two countries in the EU now looking to introduce specific FDI rules. Why is this change in policy, and how will such rules operate? What have they had in place to date, if anything?
Well, thank you, Jean-Julien, for your question. Regarding the Netherlands, well, like many other member states, it is now subject to the coordination system introduced by the EU's FDI framework. And that coordination system has been implemented in Dutch law as of December 2020. The coordination system only puts in place a mechanism to exchange questions and information regarding foreign direct investment in an orderly and confidential manner among those EU member states. And the Netherlands is also a part of that coordination system. What is missing in the Netherlands so far is a general substantive FDI screening regime. So what we do not have in the Netherlands so far is a material legal supervisory regime regarding foreign direct investment. Well, the Dutch legislator is about to do something about that. It has now drafted a legislative bill whose main objective is to create such a general screening mechanism for foreign direct investment in the Netherlands. There's no indication as yet when this legislative bill will enter into force exactly. However, it is likely that it will be sometime in 2022. Well, important to note is that the new general Dutch FDI regime will provide for a retroactive effect back to 8 September 2020. So this may be of some concern to companies that invest in the Netherlands. On the other hand, the Dutch government has indicated that this retroactive screening competence will be applied with great restraint and only in special circumstances in order to prevent evasion of the future Dutch FDI legislation. So we expect that in practice it will hardly or not be applied, this retroactive regime. Well, a few words on the reasons for the Netherlands to put in place a general FDI regime. Well, of course, it follows many other member states in the European Union. And of course, there's also a European framework that the Netherlands uses to constitute its own FDI, national FDI legislation. Next to that, the Netherlands has had some bad experiences with acquisitions of big Dutch companies in the past. For instance, the takeover of PostNL by the Belgian Postal Service. Think of the acquisition or the intended acquisition of Unilever by Kraft, the intended acquisition of AkzoNobel by PGG. Those were all intended acquisitions back in the days that the Netherlands were not really able to control, so to speak, or to subject to a supervisory mechanism. They have all been blocked on the basis of other, reasons, so to speak. But what was really lacking in the Netherlands was a general supervisory system. Well, with the new FDI bill, such a general supervisory system will be put in place. Important to note is that we already have in the Netherlands very highly sector-specific FDI legislation. Think of telecommunications, electricity and gas, but they only provide for a screening regime regarding those specific sectors. So the general FDI bill that is now in the legislative process will complement those existing very sector-specific FDI laws, so to speak. A few final words on the scope of the general Dutch FDI bill. It will focus on sectors of vital infrastructure and sensitive technology. There's nothing new in that respect. By governmental decree, the list of sectors that are deemed to be part of that vital infrastructure and sensitive technology may be expanded. So that is in the future up to the Minister of Economic Affairs to decide. In the end, in the screening mechanism, the Dutch Minister of Economic Affairs will take the final decision on notified intended acquisitions or investments. The Minister of Economic Affairs will issue a screening decision which may allow or not allow, whether or not under conditions, the envisaged intended investment in question. That's just a few words on the Dutch general FDI system or regime that is currently in the legislative pipeline. As I said, it will probably be in force in 2022, but we are not sure yet because, we still need to await the final verdict of Dutch Parliament. Back to you, Jean-Julien.
Thank you, Tobias. Can you give us insight on the situation in Sweden?
Yes, of course. Thank you, Jean-Julien. Well, Sweden at the moment have no general FDI screening rules applicable to foreign investors. However, Sweden has implemented the EU FDI framework. This does not include a notification requirement, and it does not allow the Swedish government or any other agency to prohibit an investment. Rather, Sweden has set up a national contact point for the exchange of information and views on FDI. This is the Inspectorate of Strategic Products. The contact point may order a foreign investor or the company in which the investment is intended to take place to submit information, but the Swedish rules, as said, do not provide for a general screening mechanism. Just recently, in November, a proposal for a FDI screening regime was, however, published. It is proposed to introduce rules that would allow for screening and prohibition of FDI, for instance, in essential services, which are services or infrastructure that maintains or assures societal functions that are vital to society's basic needs, values, or safety, or activities related to emerging technologies and other strategic technologies and security-sensitive businesses. The proposal entails that anyone planning to make an investment covered by the proposed act is required to notify the investment to the screening authority, the same authority just mentioned, the Inspectorate of Strategic Products. The obligation to notify an investment should, according to this proposal, arise if the investment results in a certain interest in the target undertaking, and depending on the type of target, the interest is expressed differently. In the case the target is a limited company or an economic association, for example, it is proposed that any investment where the investor after the investment will command 10% or more of the total number of votes in the undertaking through the shareholding or other participation, this must be notified. The screening authority, according to the proposal, should be able to make a decision to approve an investment subject to conditions or to prohibit the investment. A prohibition on an investment would void the transaction. As it comes to investment in listed companies, however, the screening authority may instead require the investor to sell what has been acquired. And it is proposed that this regulatory framework shall enter into force on 1st of January 2023, and the proposal has been referred to for consideration to relevant bodies. Thank you. Back to you.
Thank you very much. Thank you, Tobias. So yours, from a practical perspective, now that the EU framework has been in force for a little while, what levels of screening are we seeing, and what sectors are largely being targeted?
Well, thank you for your question, Jean-Julien. Yes, it's a good question. So what about the European coordination system regarding foreign direct investment? Well, we have seen that the member states have gradually been making use of that EU FDI coordination mechanism. We are seeing around 200 to 300 transactions reported under the EU screening mechanism, the coordination system, each year, comparable more or less to the number of merger notifications submitted to DG DG Competition, that is. But as more member states introduce their own national FDI control rules or expand their existing regimes, we expect to see those numbers of notification within the European coordination network increase in the years to come. Well, interestingly, some member states are insisting that all FDI cases should be notified under the coordination mechanism, where some other countries are only want to notify those cases for which an in-depth investigation is being initiated. So the choice what to exactly notify within the coordination system also has an impact on the numbers. As regards the Netherlands, we expect that its notification numbers within the European network will increase logically after the general Dutch FDI bill comes into force in probably 2022. Back to you, Jean-Julien.
Thank you. Now, for you, Guillaume, what does this mean from a practical and logistical standpoint for businesses that may be caught by this FDI framework? What can the businesses expect as a result of having to navigate both national reviews and the Commission review?
Well, from a practical and logistical standpoint, the new FDI framework will mean that transactions involving a foreign buyer or domestic buyer with a foreign parent company will be subject to an additional layer of complexity in considering whether any domestic FDI regime in the EU will apply to the transaction and thus trigger the cooperation mechanism. Fears have been raised regarding the complexities between the national reviews and the Commission, which may lead to the adoption of inconsistent decisions and delays. In the event that transactions are deemed to constitute FDI and are subject to a Commission opinion, Member States will need to address retrospective opinions from the Commission and other Member States. Courts may need to decide on this aspect of the EU FDI regulation if, for example, the Commission's advisory opinion on a completed transaction is to prohibit it or to invite remedial actions. And of course, in the worst case scenarios for foreign investors, transactions may be blocked by national regulators and contemplated transactions may be abandoned if they are possibly in breach of any FDI regime in any of the EU member states.
So in addition to the impact on transaction security, which Guillaume just mentioned, the extra layer of regulatory oversight brought about by FDI screening can obviously also have an impact on transaction timetables. Now, the EU FDI regulation doesn't require transactions to be suspended, but the national regimes of some member states, like Austria, do provide for a standstill obligation. That is an obligation not to close the transaction prior to clearance. Moreover, it's the FDI regulation's clear intent that member states await any opinions or comments before taking a decision. Since the standstill obligation in Austria applies until clearance, this effectively means that closing will have to be delayed for the duration of the EU cooperation, plus any additional time allotted to the national authority for rendering its decision. In Austria, this leads to a minimum duration of proceedings of approximately 2.5 months, and that applies even in simple phase 1 cases which don't give rise to concerns. And that obviously is substantially longer than the 1-month period needed to obtain merger clearance in easy cases in Austria.
Well, in other member states, like in France and Latvia, where there is no obligation to freeze the transaction while the Commission and the other member states are exchanging information, this leads to another challenge. Decision makers in France and Latvia are normally required to close their first review within 30 days, that is to say before the minimum 5 weeks, which the EU FDI regulation foresees for the Commission and Member States oversight process. In France, the Commission requires Member States to complete a set template of information, whereas each Member State has its own form of notification with varying degrees of information to be provided regarding the investor and target. Parties should expect and be prepared for follow-up questions to complete this detail where it was not required in their country forms, and for that information to be shared more broadly across the EU network. Also, we are seeing that reviews are more strenuous, asking parties for more detailed responses and issuing more requests for information. This can often lead to stopping the clock on the review process. Indeed, there is an additional obligation to produce the findings in multiple languages. There is limited transparency regarding the nature and content of the interactions between Member States and the Commission. Beyond answering questions to assist Member States in gathering the necessary information and being made aware that an authority is waiting for feedback. Transaction parties are largely left to await the completion of the period within which the Member States and the Commission may provide comments, issue an opinion to understand and address any possible concerns. Back to you.
Thank you, Guillaume. An important element of the FDI framework and the increase in the number of countries introducing FDI rules has been to ensure a more level playing field and to better enable member states to safeguard national security or assets. After reinforcing its control over FDI over the past few years, we see that the Commission has recently adopted a draft regulation that aims to close a regulatory loophole by addressing distortions of competition on the European market caused by foreign non-EU subsidies. Tobias, this time I'm sure it's for you, this question. Would you care to comment?
Yes, that is right, Jean-Julien. On 5th of May this year, the Commission adopted a draft regulation to this effect, and is close to finalizing new legislation powers that would enable it to crack down on market distorting subsidies from foreign governments. The background is that the EU seeks to defend itself from perceived unfair competition from China and other countries. So while FDI rules have been used by France and other member states to protect assets considered strategic to national interests, this proposed regulation has been introduced in the context of the Commission's efforts to protect European strategic assets. While subsidies granted by member states to their companies are strictly regulated through state aid control, foreign public financing granted to certain non-EU companies have gone largely unchecked. So this financing can take different forms, like interest-free loans, unlimited state guarantees, tax exemptions, or reductions for foreign investments or specific public financing. Such financing could be problematic if it were granted by member states to an EU company and would be subject to close scrutiny. This has not been the case for non-EU public financing, and the regulation aims at correcting this loophole. Given the EU is the destination of a third of the world's investments and is home to some 100,000 companies owned by foreign entities, the EU wishes to strengthen and adapt its regulatory tools to the new challenges of competition today.
Okay, can you outline this proposal and how it will work?
Yeah, of course. There will be 3 tools that will allow the Commission to investigate financial contributions granted by the public authorities of a non-EU country, which benefit companies engaging in economic activities in the EU, and if necessary, to remedy any distorting effects on the market. The first two tools cover situations in which the foreign company intends to, one, acquire a European company with a turnover exceeding 500 million euros, and the foreign financial contribution is at least 50 million euros. Two, bid in an EU public procurement worth more than 250 million euros. Foreign subsidies worth less than 5 million euros would, however, be deemed unlikely to distort the EU single market. Ex-ante notification to the Commission of any financial contribution received from a non-EU country would be required. In case of a non-notification, the Commission may impose fines. Depending also on the situation, the Commission would have the power to impose commitments and remedies, such as divestment of certain assets, or even prohibit the notified operation. The last tool, known as the General Market Investigation Tool, is probably the most significant and could be implemented automatically by the Commission on suspicion of a foreign subsidy for all situations, mergers, public procurement procedures below the automatic notification threshold. The draft legislation is open to review by Member States and the European Parliament. However, it could be some years before the regulation actually becomes law, and the proposals in the meantime could change. Nonetheless, this is an important development in this context. Thank you. Back to you.
Thank you, Tobias. So, for France and Austria, are there any other mechanisms the Commission has recently introduced to monitor more foreign investment into the EU that investors should be aware of?
Yes, indeed. The Commission published new guidance on the application of the referral mechanism set out in Article 22 of the EU merger regulation, which allows for mergers falling below national merger thresholds to be nevertheless referred to the Commission if they might affect trade between member states and threaten to significantly affect competition. This mechanism has just been put in practice in the acquisition of the innovative biotechnology company Grail by the US company Illumina, the world leader in genomic sequencing.
Yeah, so thanks Jean-Julien and Guillaume, and I'm happy to chip in here because for a few years now, the Austrian Federal Competition Authority has been at the forefront of authorities which made Article 2 referrals to the European Commission. And this has to do with the fact, as some of you may know, that the Austrian merger control regime is rather notorious for creating red tape in cases which had little to do with the Austrian market. Based on the current filing thresholds, a merger filing can be required even if the target has zero sales to Austria. The good news, by the way, is that this will change when our new merger filing thresholds finally become effective at the beginning of 2022. But what these low thresholds did is they allowed Austria to pick up tech acquisitions which were not notifiable in other member states because the target's turnover was still limited. Since Austria is a small member state and doesn't really have the clout to examine international tech deals, the Austrian authority referred a number of these cases to the European Commission under Article 22. The first case was the acquisition of Shazam by Apple, which was cleared unconditionally by the Commission. More recently, the Austrian Federal Competition Authority referred the acquisition of the CRM platform provider Customer by Facebook, now Meta, which is currently undergoing a phase 2 investigation in Brussels. The timing impact of Article 22 referrals is quite evident when you consider that this transaction was notified in Austria in March of this year, and the provisional deadline for the Commission's decision is now the 28th of January 2022. Now, digital economy transactions like Facebook Customer and innovative pharmaceutical transactions like Illumina Grail are the kind of deals which the Commission has in mind as targets for referral under its Article 22 guidance. Ironically, the Austrian authority has recently stated that it doesn't agree with the Commission's view that Article 22 allows member state authorities to refer transactions to the Commission, even if they do not have jurisdiction to review these transactions under their own national merger control rules. This question has already been raised in Illumina Grail, where the French competition authority did not have jurisdiction under French competition law and still referred the case to the Commission. This will likely become a major battleground in future referral cases until it will be resolved by the European Court of Justice. And back to you, Jean-Julien.
Thank you very much. Definitely this Illumina Grail case is very interesting and will give to major developments in the coming weeks for sure. So thank you all for these very interesting insights on the different regulatory tools available to the EU to protect EU and national strategic assets. Now it's time to have a quick Q&A session, and my first question goes to Tobias. So you were mentioning investments in security-sensitive businesses, which would be covered by the proposed FDI screening rules. Is there not already rules related to investments in security-sensitive businesses?
Yes, it is correct, Jean-Julien, that there are rules on protective security relating to acquisitions applicable to certain entities. The rules relate to activities that are in the greatest need of protection from a national perspective, such as energy production, distribution, mail, telecommunication, and defense. The rules do not, however, confer obligations on the investors. Instead, entities conducting security-sensitive activities who intend to sell all or any part of the security-sensitive business or property that is of importance to Sweden's security must perform a security assessment and consult with certain appointed authorities. And these authorities can, in certain cases, decide to prohibit a transaction.
Thank you. My next question goes to our Austrian representatives. What about investments by EEA subsidiaries or foreign corporate groups? Do they also require foreign direct investment approval?
Yeah, thanks. That's a very relevant question, since investments by EEA nationals obviously benefit from the EU fundamental freedoms. And in past judgments, the European Court of Justice has indeed found that FDI mechanisms established by member states were incompatible with the freedom of establishment. But these judgments are from the early 2000s and early 2010s. And as Guillaume mentioned, there has been a significant shift in the public debate since then, and security concerns raised by public investment, by foreign investment, are much more at the forefront than they were then. The FDI screening regulation explicitly refers to potential risks arising, among others, from indirect control by foreign governments. While the regulation leaves it to member states to define the circumstances which trigger the screening, there's a clear trend that modern FDI regimes also cover for indirect foreign investment. This is also the case for Austria. The Austrian FDI regime covers both direct and indirect investments made by non-EEA investors in Austrian companies. In addition, it even covers cases where there is no change in the direct ownership of an Austrian company at all, but where the change occurs upstream. For example, if a US investor acquires 25% in a German company which holds an Austrian subsidiary. The situation is quite similar in many other member states. Jean-Julien, I understand you will discuss this indeed in more detail in the second session.
Yeah, that will be the case. Again, for Austria, Austria has been sending quite a few cases to the Commission and the other member states under the FDI screening regulation. Is there any particular reason for this?
Yes, I mentioned earlier that we had a low merger filing threshold, and now indeed we also have a lot of FDI cases. But the number of cases which we are sending to the screening mechanism isn't just due to low jurisdictional thresholds. There's also another reason for this. To give you a perspective on the figures, Joost mentioned earlier that there were a total of around 200 transactions which were subject to the cooperation mechanism. Now, the Austrian Minister of Economic Affairs reviewed a total of 70 transactions in the first year of the new FDI regime. And in all of these cases, it shared information with the European Commission and the other member states under the screening mechanism. And the reason for this is that the Austrian authority doesn't engage in a preliminary review prior to sending the case to the Commission and the other member states. The case is sent immediately within a few days of receipt of the notification. There is no prior screening, and as a consequence, the Austrian authority also shares information on transactions which clearly do not give rise to any concerns. There actually is a way to avoid losing time due to the FDI screening regulation under Austrian law, but it is unfortunately rather poorly designed and doesn't really help in practice. Companies can request the minister to issue a non-action letter instead of entering into review proceedings, but the deadline for a non-action letter is 2 months, which is almost as long as the 2.5 months needed for phase 1 review proceedings. In addition, if the minister decides not to issue a no action letter, but instead initiates phase 1 proceedings, this takes the total duration for phase 1 up to a total of 4.5 months. As a consequence, investors generally do not request no action letters, and this, at least in part, explains the large number of cases sent by Austria to the cooperation mechanism. Back to you, Jean-Julien.
Thank you, Heinrich. My next and final question goes to Joost. If a sector-specific screening applies to potential FDI under Dutch law, but the threshold or assessment criteria for the sector-specific screening are not met, will the general screening mechanism still apply?
Thank you, Jean-Julien. Yeah, that's a good question. And the answer basically is no, this is not the case. The draft Dutch FDI bill explicitly mentions that the general screening mechanism will not apply to investments in sectors subject to a special FDI regime. So the thresholds and or assessment criteria in that sector-specific legislation are tailored to the sector in question and are basically followed. So if those thresholds or criteria are not met, the intended investment or intended acquisition will not be assessed either under the special screening mechanism nor under the general FDI regime. There's just one small reservation. The Dutch general FDI bill is still in the legislative process, as I already told. So in theory, it could still be modified, but we expect that this principle, as I just discussed, will be maintained. Back to you, Jean-Julien.
Thank you, you're duly noted. So this is the end of our session. I would like to thank all our panelists and all our audience. During the next session, we will look more closely at some of the general trends across the different regime of certain member states, including Germany, Spain, UK, and France, as well as practical guidance on the impact of FDI screening rules on M&A transaction. So again, thank you very much for your attention and goodbye.